This We the People News, educational purposes only. Okay? Not an attorney, not giving legal advice.
So this is another one. Says, so this is French too, by the way. A pleading stating that although the facts alleged in a complaint may be true, they're insufficient for the plaintiff to state a claim for relief and for the defendant to frame an answer. In most jurisdictions, such a pleading is now termed a motion to dismiss, but the demurrer is still used in a few states, including California, Nebraska, and Pennsylvania. So, yeah, some cases you have to file a motion to dismiss. Depends on the state. They go and change the, again, what do their civil laws say? The word demurrer, derived from the Latin demurrere or the French demurrer, meaning to wait or stay, imports that the party demurring waits or stays in his proceedings in the action until the judgment of the court is given, whether he's bound to answer to so insufficient a pleading. So the pleading itself, the complaint, is defective. Each party may demur to what he deems an insufficient pleading of the other. The demurrer was general when it was to matter of substance, and it was special when it was made to matter of form, and must specifically point out the defect. So, in other words, I'm a state national, and he's got no standing to say anything about me. See what I'm saying?
Right, that's it. You would not be found to answer because the pleading was sufficient.
That's right. Demurrer, a pause or stop put to any action upon a point of difficulty which must be determined by the court before any further proceedings can be had therein. For in every action the point of controversy consists either in fact or in law. If in fact, that is tried by the jury, but if in law, that is determined by the court. A demurrer, therefore, is an issue upon matter of law. It confesses the facts to be true, as stated by the opposite party, but denies that any law arising upon those facts, any injury is done to the plaintiff, or that the defendant has not made out a lawful excuse.
Has made out. You said has not. Word.
Or that the defendant has made out a lawful excuse according to the party which first demurs. That is, rests or abide in law upon the point in question, as if the matter of the declaration be insufficient in law, as by not assigning any sufficient trespass, that the defendant demurs to the declaration. If, on the other hand, the defendant's excuse or plea be invalid, as if he pleads that he committed the trespass by authority from a stranger without making out the stranger's right, here the plaintiff may defer to the plea, and so in every other part of the proceeding. Right. So that's Tomlin's Law Dictionary. That's an old definition, right? It's in that if all the facts the plaintiff presents are true, the evidence is not, as a matter of law, sufficient to entitle the plaintiff to a judgment. However, a voluntary non-suit, unlike a demurrer or a directed verdict which resolves the action on the merits, may result in another trial of the cause. And that's American jurisprudence. A demurrer does not mean a plea. The statement of the plaintiff's cause of action in equity is called a bill. to this bill, the defendant, unless he could protect himself by demurrer or a plea, was obliged to put in an answer under oath. The Principles of Equity, a treatise of the system of justice administered in the courts of chancery. So that's from a book. It's all bills. Everything's a bill. I have exclusive content available on HowTube. It's $9.99 a month for the videos plus unlimited email consultations. I'm not a liar. Well, I'm an attorney. But I can tell you, no, I'm not a liar. But I can tell you what I would do and where I would find the forms. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit. Some of my exclusive content is an Arlington private information share. I'm just going to check on YouTube and see what's happening. Okay. So what we'll do is we'll go through this presentation, and then I'll go through a demurrer that I helped someone file recently, and we can look at that, the text on what the demurrer basically says. Okay. So quasi-contracts. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in the strict primary sense denote a punishment, whether corporal or pecuniary. Notice the word pecuniary. Okay, we're going to be talking about that a little bit more later, I think. Imposed and enforced by the state for a crime offense against its laws. The noun penalty is defined forfeiture, or to be forfeited for non-compliance with an agreement. So, where's the contract? Both in Roman and English law, there are certain obligations which were not in truth contractual, which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it. A quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of the facts under circumstances that making it inequitable for him to retain the benefit without payment of its reasonable value. And so it's all about equity, okay? These are all, that's about trusts, okay? It's all trust law and equity. Penal action, quasi-constructive contracts are based solely upon the legal fiction of the law. And this is where that's come from, is the minor estate. Entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company. Trust, the estate of a decedent or the estate of a living person, such as an incompetent or a minor. A minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. So, this is National Mutual Insurance Company versus Tidewater Transfer Company. Let me see if I can find one of these demurrers. And let's look at that to get an idea on what that's all about. So this is what I did with a friend, with actually my brother.
Alrighty. Do some We the People news. Bye, y'all.